Good day, Crime Talk aficionados. Bryan Kohberger's attorney is going to be busy. Karen Reed goes to court tomorrow, a preview of what to expect. Is this guy a victim, or did he kind of get what he deserved? An example of why you must be so careful about your surroundings and people you meet. This goes for everyone, not just the ladies. A death row inmate shares his last words and our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. Welcome to Crime Talk. My name is Scott Reich. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and remember, you can listen to us anytime on any of your favorite podcasting apps. All right, let's go ahead and get straight to the docket today. So let's open the record for August 8th of 2024. That's right, Bryan Kohberger's attorney is going to be busy. I hope this doesn't affect the trial date in Mr. Kohberger's case. So the lead attorney for Bryan Kohberger, obviously, he's charged with killing 4 University of Idaho students back in November of 2022, will also be the lead defense attorney in another high-profile case in Idaho. That's right. Now, Ann Taylor, Kohberger's top attorney, was assigned Wednesday to head up the defense of Skylar Mead. Now, that is the Idaho prisoner who is charged with killing another man there in Idaho after escaping from the corrections officials at a hospital in Boise during a shootout in March. So like Mr. Kohberger, Mr. Mead faces the death penalty if found guilty by a jury. Now, Kohberger's murder trial is scheduled to start in June of 2025, while Mead is set to be arraigned Thursday in the Nez Perce County Courthouse. Now, initially, another attorney was assigned to represent Mr. Mead, but the attorney did not meet the qualified requirements and can only be co-counsel in this case and wasn't qualified to do the lead counsel issue. So Taylor is only one of 13 public defenders and kind of alternate private counsel in the state approved by the Idaho Public Defense Commission to work as lead counsel in a death penalty case. She is also the only one grouped in that northern Idaho area where it seems like there's a lot of killing going on. Anyway, if you didn't already know this, Taylor left her position last month as the chief of the public defender's office up there, and she has now transitioned into private practice. The attorney, Jay Longsdon, who is also co-counsel on Kohberger's defense team, is now acting as the interim chair for the public defender's office. Now, Mead, who is serving a 10-year prison sentence in the Idaho Maximum Security Institution, was taken to the hospital in Boise after prosecutors say he faked an injury. Mead had coordinated a plan to escape from the Boise hospital with the help of the alleged co-conspirator, Nicholas Umpenhor. Yes, the plot thickens. She is going to be busy. Like I said, I've said this in the past, the death penalty cases, we had one that was considering going death. We convinced him not to, so we didn't do it. But everyone that I've known that has done a death penalty case, they usually had one death penalty case, and it was a full-time job. So to have 2, that's right, she is going to be one busy lady. So she must be good. I think she's good. I really do. I think Miss Kelly is very good. Every time I've seen her in court, she runs circles around the prosecutors in that case. Next, Karen Reed returns to court tomorrow for a motions hearing. What should we expect? That's right, Karen Reed case will be in court on Friday as the judge is expected to hear arguments on the motion to dismiss 2 charges that have been called into question in the weeks after the trial ended in a hung jury. So Reed's defense team has stated in multiple court filings that 5 jurors have come forward to tell them that the jury agreed Reed was not guilty of 2 of the 3 charges against her in the death of her Boston police officer boyfriend. That was John O'Keefe. And the charge was second-degree murder and leaving the scene with injury or death. Now, Reed's defense team states it's received unsolicited communications from jurors who deliberated in her first trial, indicating in no uncertain terms that the jury had a firm 12 5-0 agreement that Miss Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the 2nd degree. Now, the filing also stated that the jury unanimously believed that Reed was not guilty of count 3, which is leaving the scene of a fatal car crash. The jury was unable to agree on the manslaughter charge that Reed also faced in connection with the O'Keefe death back in January 2022. That one was 9-3 for guilty. So what was the judge to do? Well, the judge declared a mistrial after the jury sent a note indicating that they were at an impasse and future deliberations would be futile. It was the 3rd note the jury sent stating that they could not reach a unanimous decision during the 5 days of deliberations. And the defense has since filed 3 memorandums in support of dismissing 2 charges, with the most recent coming on Monday. Now, the memo stated that the jury had determined that even if Reed hit O'Keefe with her Lexus SUV, she did not realize that she did it. Now, Reed's legal team hopes to keep their client from being tried again on the same charges. So the defense put in their motion, they respectfully renew its contention that the jury acquitted Miss Reed on counts 1 and 3, or alternatively, there was no manifest necessity for a mistrial as those counts, and therefore double jeopardy has attached. Now, prosecutors in this murder case previously filed documents in opposition to the defense post-trial motions to dismiss the charges against Miss Reed, calling the claim made by Reed's attorney unsubstantiated and sensational. Well, defense attorneys said in a follow-up filing that the retrial of Reed should not be allowed, calling the state's continued push for a conviction in the death of Mr. O'Keefe grossly unfair. Now, the judge then indefinitely extended an order impounding the jury list from Reed's trial, citing one juror's credible and reasonable fear for their safety. As you may recall, Reed is accused of killing O'Keefe by striking him with the SUV and leaving him to die in a snowstorm back in January of 2022. Prosecutors said that Reed and O'Keefe had been drinking heavily before she dropped him off at a party at the home of Bryan Albert, a fellow officer. They then said that she hit him with the SUV before driving away. Now, the defense said no, Miss Reed is the victim in this particular case, saying that Mr. O'Keefe was actually killed inside the fellow police officer's house, Mr. Albert's home, and then dragged outside and left for dead, obviously trying to frame Miss Reed. The trial is tentatively scheduled for January 27th of 2025. So I've said this again, and boy, I took a lot of heat for it. The defense was all about mistrial, mistrial, mistrial every time one of those notes came out. And the jury never said, hey, we're in an impasse on one count. And you can say, well, they didn't know they had to be all 3. They could have said, we've reached a verdict on 2, but not 3, and that one we're hung on. The prosecution, the defense, and even the judge could have said, hey, let's take a verdict on any counts in which they could agree upon. I mean, there's a lot of fault to go around here. But the bottom line is, ladies and gentlemen, the judge declared a mistrial, right or wrong. I don't see her reversing herself. Trial court judges rarely do that. I don't see her saying, I made a mistake and therefore we're going to prejudice the prosecution and not be able to go forward. The prosecution was the one that said, don't declare a mistrial. The defense wanted it. The judge basically said, fine, mistrial, and then sent everybody home. There's a lot of blame to go around. I don't think they're going to dismiss it. The prosecution can decide if they want to do it. But like I've said before, juries are a unique group of people. Sometimes they have personalities of themselves. They take on a life of themselves. And who's to say that the next jury wouldn't have a completely opposite opinion and decision as it relates to Miss Karen Reed? So obviously I will be watching, hopefully with you all. I'll try to be here myself, and we'll see what the judge does. My guess is the defense motion to dismiss counts 1 and 3, denied. Next, is this guy a victim, or did he deserve what he had coming? So please meet Jacob Root. Now, he was arrested back in 2022 after police say they found him in a stolen vehicle. And according to the police, Root hit a marked police car with that vehicle, then fled, was found walking to the vehicle from a gas station later, and then tried running from the police again. Now, according to Mr. Root's lawyers, though, Root was left paralyzed because of the efforts to arrest him. Now, in body cam footage, that's right, you can take a look at this, Root appears to be hit with a taser while entering the street, causing him to fall off the curb and hit his head. Well, police and Root's lawyer said that this was what left him paralyzed. Everybody agrees on that. Now, Mr. Root says that the officers made him a prisoner in his own body. As he addressed the media, as they let everybody know that they were filing a $100 million lawsuit against the arresting officer, Robert Comstock, and the city of Colorado Springs. Well, guess what? The city is standing behind Officer Comstock, and they're saying, we're not paying you one penny. Now, the Civil Action Investigation Committee has recommended that the city represent the above-named officer, Officer Comstock, as required by the Colorado Governmental Immunity Act and the Peace Officers Liability Act. The peace officer was acting in the course and scope of his employment and was acting in good faith. As usual, it is recommended that the city reserve the right not to pay any award of punitive damages, the recommendation reads. Now, Root and his lawyers say that they believe that Officer Comstock not only made the wrong call when using the taser, but did so against standard operating procedures. It was that perceived violation that Root said he blames for his current condition, not the fact that he was running from the police and he had hit the police car in a stolen car and fled, and then fled again. Anyway, Mr. Root says he would have rather have gone to prison than be in this wheelchair. He says he was free and now he is stuck. So the Colorado Springs Police Department reiterated that they stand by the results of their internal investigation, which found Officer Comstock did not violate any policies, and they have exonerated him of any wrongdoing. Officer Comstock is a valued employee, and he is in good standing with the department. It's because of the fact that the investigation was internal that Daniel says they are bringing the lawsuit to federal court. And he said, beyond the financial reward, it's not about the money, ladies and gentlemen. Of course it is. It's about the money. It's always about the money. Are you kidding me? An attorney on $100 million? You're thinking making $35 million in a retainer for your win if you get that? It's about the money. It's not just about bringing change within the department, like using non-lethal force, like a taser. I mean, anyway, little facts here. On May 16th, at approximately 1:30 p.m., law enforcement personnel with the Beat Auto Theft through Law Enforcement Task Force, which includes personnel from the Colorado Springs Police Department, El Paso County Sheriff's Office, and the Colorado State Patrol, located at a stolen Ford Fusion in the parking lot of a motel in the 3900 block of North Nevada Avenue. Officers attempted to apprehend the suspect, later identified as Mr. Root, driving the stolen vehicle. The suspect fled in the vehicle, striking a marked police cruiser in the process. Officers did not continue to pursue the suspect at this time, so there is limited body-worn camera footage of this initial contact. However, approximately 20 minutes later, task force officers located the stolen vehicle in the parking lot of the convenience store on Airport Road. As uniformed officers approached the vehicle, the suspect was walking from the store to the car. And when the suspect saw the officers, he fled on foot. Multiple officers pursued the suspect, also on foot, lawfully ordering Mr. Root to stop. Officers identified themselves as police officers and warned that force would be used if he did not stop. Mr. Root continued to run from officers, and during the pursuit, an officer with an outside agency attempted to detain the suspect, Mr. Root, with using a tool known as a bolo wrap, but it was completely ineffective. Officer Comstock commanded the suspect to stop running, and Officer Comstock warned the police canine would be used if he did not stop. As the suspect continued to evade officers and approached Airport Road, Officer Comstock deployed his taser. The suspect fell. The officers took him into custody. Officers rendered medical aid and called emergency services to respond. During his medical treatment at the hospital, the suspect was found to be paralyzed. While our goal is to complete every call for service in the safe manner, unfortunately, the suspect sustained injuries during his attempt to flee officers who were readily identified and had commanded him to stop. I don't know, ladies and gentlemen. Tell me if I'm wrong. And don't get me wrong. I mean, there are lots of good police officers. There's bad police officers. We need to get rid of the bad police officers. I don't see where this officer did anything wrong at all. But yet Mr. Root steals cars, flees from police officers, not once, not twice, continues to run after being told to stop because he thought he could get away with it. I mean, you gotta have to admit, there's kind of an assumption of the risk when you run from police that maybe bad things are gonna happen to you. I mean, I don't know what to tell you. I would give this guy, Mr. Root, $0. $0. And I would be extremely disappointed in the El Paso County and the Colorado Springs Police Department if they pay even $1 to this guy. They need to make this as expensive as possible for these attorneys, taking this on a contingency fee. I'm sure they're hoping for a quick payout. Don't pay them a penny. Do not pay a penny. Let me know in the comments if you think this guy deserves a penny or if he deserves $100 million, ladies and gentlemen. It sucks. I wouldn't want to be paralyzed. But if I kind of was running from the cops, it's kind of like expect to what happens. I mean, he should have learned to roll or, do something. Put your hands down. Oh, I guess that happens. Your body kind of freezes up, doesn't it? I think it's reasonably foreseeable that you could hurt yourself. Don't run from the cops, ladies and gentlemen. Don't run. You resolve it in court. All right, next on the docket. Let me give you an example why you need to be so careful out there. So a woman who died last week under suspicious circumstances in unincorporated El Paso County. Yeah, it's a busy day for El Paso. I don't know, all our stories are from Colorado today. Anyway, a woman who died last week under suspicious circumstances in unincorporated El Paso County here in Colorado had gone to the alleged killer's residence and was reportedly put into a chokehold and died, according to the arrest affidavit. Now, Jorge Meza Alarcon Jr. faces first-degree murder charges for allegedly killing Annabelle Floren Wyant. She was only 18 in his residence in El Paso County on Thursday morning. Well, El Paso County deputies found Miss Floren Wyant dead inside the residence with her pants and underwear pulled down to her ankles and blood near her ear at about 3 a.m. Now, a friend of Miss Floren Wyant's told the police he dropped her off at the residence around 1 a.m. because Meza Alarcon was a subscriber of hers on social media platform and that she had come to collect money from him. That's weird at 1 a.m. Anyway, Floren Wyant told the friend that Meza Alarcon was weird and requested to periodically check up on her. After about an hour and a half, the friend stopped hearing from her, so he called the police. Now, during an interview with police, Meza Alarcon, who had visible injuries to his face, told police that Floren Wyant agreed to meet up in exchange for money or sex. She was having allegedly sex with her subscriber? Ooh. Anyway, he initially said she had allegedly hit him with something like a phone when he went to pay her, causing him to black out. When he regained consciousness, however, Mr. Meza Alarcon said he was walking on a street, which was about 3.5 miles away from his residence. He then dialed 911 and reported the assault. Law enforcement retrieved an iPhone 15 with a cracked screen and a gold case from him. In the arrest affidavit, it states that later in an interview with Mr. Meza Alarcon, he said that Floren Wyant had already threatened him before, and he saw a vehicle idling outside their residence, so he was scared that the person in the vehicle that was there for Miss Floren Wyant would attack him. So after being hit by the phone, he put her in a leg lock and then transitioned to jiu-jitsu chokehold, adding that all his weight was on her neck and that he was pulling on her head. Then when investigators asked him if he knew Floren Wyant was dead, he stated he was trained and knows how to do locks, adding that that chokehold is used to, you only have 2 to 3 taps in you. The detective wrote in the affidavit that Mr. Meza Alarcon had an extreme indifference to human life when he applied the chokehold, which he reasonably knew would create a grave risk of death. Now, Mr. Meza Alarcon was scheduled for his first appearance today in court, where bond will be set probably in the amount of $1 million. Be careful, ladies and gentlemen. You shouldn't probably be going to a subscriber's house at 1 a.m. I can honestly say I have not gone to a single subscriber's house ever, let alone at 1 a.m. Now, I'm not sure what she was doing there at 1 a.m., and he said he was paying her. I don't know what social media she's on, if it's like OnlyFans or something or what, but you got to be careful. Which is a great transition into today's sponsor, CrimeTalkSearch.com. Go to CrimeTalkSearch.com, sign up for that background subscription service so that you can have access to all the data in the world, or at least here in the United States, and you can find out if people have criminal histories. Are they on a sex offender registry? Are they married? Do they own their own home? Are they who they say they are? Go check them out. Remember, when you sign up for that background subscription service, you sign up. You can do as many searches as you desire, as long as you have that, and you can cancel at any time. Go to CrimeTalkSearch.com. It could save your life. It's money well spent, ladies and gentlemen. We use it here at the office on a daily basis. You'd be surprised of all the things that you find out about people. Next on the docket, the last words of a man right before he's executed. So Utah finally got around to executing their first inmate since 2010. Well, he kind of accepted his fate moments before he was lethally injected and insisted he had changed since his murder that he committed some 25 years ago of his girlfriend's mom. So Tabaron Honey was executed in the Utah State Prison early Thursday morning for the 1998 murder of Claudia Ben. He stated, quote, "From the start, it's been, if it needs to be done for them to heal, let's do this." Now, he said that right before the injection. If they tell you you can't change, don't listen to them. To all my brothers and sisters in here, continue to change. I love you all. Take care. His last words, I like the let's do this thing. I mean, listen, you're going to be executed. You think you'd be prepared for that, right? I'd be like, let's bring it on. Let's do this thing. You're not expecting a last-minute reprieve from the governor. Let's do this thing. Anyway, Mr. Honey was pronounced dead at 12:25 Mountain Standard Time, about 17 minutes after he tapped his foot and mouthed, "I love you," to his family members who were in the witness chambers. Now, Mr. Honey's last meal before his execution was a cheeseburger, French fries, and a milkshake. A fine selection indeed. And the Utah Department of Corrections also stated that Mr. Honey spent the evening with his family before his execution. Now, just to put a little perspective into what got Mr. Honey there before we all start feeling really sorry for him, was that he was convicted of aggravated murder in July of 1998 for the death of Claudia Ben, after he broke into her house in Cedar City and repeatedly slashed her and stabbed her to death while her grandchildren, including Mr. Honey's own then 2-year-old daughter, were home. Needless to say, when the police were called by neighbors in the early morning hours the following day, they found him in Ben's garage with blood under his fingertips. He admitted during his arrest, "I stabbed her, I killed her with a knife." Forensic investigators who went to the home found that Honey had cut the tragic grandmother's throat so deeply, at least 4 times, ear to ear, that the knife reached her spine. They also found he had stabbed her several times in and around her genitalia, as well as there was evidence that he had sexually abused one of the grandchildren immediately after the death. So despite admitting 2 days ago that he was a monster to the state parole board during his final appeal against the death penalty, he had spent a quarter of a century trying to fight the sentence, which was handed down in 1999. Some people will be sad. Some people will be happy. I don't know. It's the law. If you don't like the law, change it. It only took 25 years to get there. What can you do? And then finally today, our dumb criminal of the day. Once again, a spaghetti dinner turned violent when Anthony Fiacco threw the pasta at his mother, striking his mother in the head and leaving her splattered with sauce, according to police. Will the tragedies never end? Anyway, investigators say that Mr. Fiacco last evening had a verbal argument with the victim, his mom, termed physical, who resides with him. The spaghetti made contact with the victim, who had spaghetti sauce in her hair once the police arrived. Mr. Fiacco then allegedly fled the home when the police officers were coming, and after being spotted hiding behind a bush in the backyard, Mr. Fiacco sought to run away but was quickly arrested by police. Good thing they didn't tase him. Anyway, Mr. Fiacco was charged with domestic battery for the spaghetti incident as well as resisting arrest. He was booked in the county jail on a couple of misdemeanors. No weapon was seized. That's right, ladies and gentlemen. The spaghetti was not seized and taken into evidence. Police should probably carry at least a Ziploc baggie or some sort of Tupperware so they can start seizing these food items so that they are there for trial. Anyway, Fiacco appeared in court where the judge ordered him to have no contact with his mother, and he cannot possess any offensive food items that will cause somebody pain. I just made that up. Anyway, Mr. Fiacco, who also uses the surname Edlin, has prior convictions for battery, which is assault, trespass, violating probation, and throwing a deadly missile into a building. Ladies and gentlemen, you see, throwing missiles is a gateway crime. Next thing you know, you're throwing spaghetti at your mom. Where does the madness cease, ladies and gentlemen? Oh, I say right now. I say no more food crime. Beginning now. All right, that's all we have for you today, ladies and gentlemen. I hope you enjoyed the show. Have a wonderful day. We'll see you next time on Crime Talk. And remember, the Constitution matters.